Thank you, Sheila. We are back after a lunch break, and we're going to continue with the questioning of Mr. Diede. Let's see, Mr. Sayer or Ms. Bradview, do you have questions? Mr. Rankin, do you have questions?
Thank you, Madam Hearing Officer. I do have a few. Good afternoon, Mr. Diede. How are you today?
Very well, thank you.
Thank you for the background on some of that. I appreciate it. It's helpful for me to learn some new terms and actually see some new photos as well. My name's Adam Rankin. I represent OCC in this matter. I don't suppose that you were involved with any of the discussions between OCC and applicants in this case, so I'll probably save my comments for appreciation for the division's engagement for another witness. But just wanted to confirm that you weren't involved with any of those discussions, were you?
No, I was not.
Okay. In your testimony, I think it's slide 1. Maybe I'll go ahead and pull it up. Oh, there's I have my colorful slide up there. And this slide number 4 here, you talked about 2 different groups or categories of wells, none of which is formally defined, but one is the orphan well and the other is the forced plugging well. And I understand that, just so I understand, the wells that you gave examples of in your testimony, were those all what you would call orphan wells?
The 2 Cato San Andres were would be what you would call forced plugging. The coal was kind of in a category all to itself since it was an old P&A that we were just repairing. But yes, the Buckskin well was a orphan well.
So the Cato San Andres were wells that OCD plugged, right?
There was an operator plugging those under more of a forced plugging but that operator was not even, it's a rather complicated arrangement, my understanding, so I don't have all the details on that, but it was probably a forced plugging with some input from the state since that operator was not currently an operator within the state of New Mexico.
Okay, yeah. All right, I just want to make sure I understood the examples that you were giving, whether they were orphan or which ones were forced. Okay, so I'm interested in both, but the forced plugging, and you've only been with the division now for a little over a year and a half, about a year and a half or so, right?
That is correct.
In the year and a half you've been with the division, have you seen an increase in these forced plugging type situations?
I can't speak to that because I haven't been tracking. So I wouldn't be able to say whether it's increasing or decreasing.
Okay. And just, okay, what role do you have or does the division have when it's a forced plugging situation where it's a third party operator coming in? What role does the division have in that process?
I'm doing some oversight similar to what I would do on an orphan well plugging. And it might have to do in some regards to the fact that the operator doesn't always have all of the information that they would normally have on their own plugging. So I will get involved in formation top picks to make sure we have all of the formation tops that the conditions of approval will require. And then offer some guidance where I can along the way as they do their operation.
Now, as to the forced plugging wells, sometimes it's the case that the operator, the designated or the division designated operator of those wells is no longer viable. And that might have been the case with Cato San Andres wells, right?
Could you restate that, please?
Sure. I guess my question is like for the force plugging wells, operators or division designated operators of wells that are, force plugged or identified as being to be force plugged by the State Land Office or the BLM. It's sometimes the case that the division designated operator is no longer a viable entity, right? Like for bankruptcy or some other reason, they're no longer a valid, they're no longer around.
The previous operator of record would not be viable anymore at that point, yes.
But is it always the case that the division designated operator of these force plugging wells is no longer viable? Sometimes they just refuse to do the work, right? So then BLM or the State Land Office will look to the lessee of record or another operator of record to do the work. Is that correct?
I can't answer that accurately because I don't have the information to substantiate it one way or another.
Okay, so yeah, you don't know whether it's always the case that a force plugged well, the operator is always defunct or not viable, right?
That would be correct. I do not know those things.
Okay. And so it's not always the case that or you can't say whether it's always the case that a force plugged well is always an orphan well, right?
I could not state that either, no.
Yeah, okay. One thing that caught my ear, I was just kind of interested in understanding a little bit about it. I think it was when you were discussing slide 6. You said something to the effect that with every transaction, every transfer of operatorship, the quality of the data for the well or facility degrades or declines. What did you mean by that? And how does the data decline over time with each transfer or transaction?
Okay, well, I stated that the quality of the data diminishes because the records that you would normally have if you are the operator of a well, like some of the clients that I worked for before coming here, they had a whole file room of files that you could go through to get all the information, every bit of history of the well that was recorded in those records would be available to you. In this particular case, whether they're orphan or whether they're being force plugged, if the ownership has, changed hands a number of times, those records are often never available to the final holder, the final person that has to do the work. They just don't exist sometimes.
I see. So the distinction you're making is that, or the point you're making is that because the entity no longer exists, those records that are not public are not available to the OCD or the operator who's been tasked to do the force plugging, correct?
That would be correct.
And so then all they're left with is whatever may be available publicly with the OCD, correct?
That is correct also.
All right. And so the older the well, then the less public information is probably available on that well, correct?
Generally, but not always.
Yeah. Okay. Um, all right. So then the other wells that you identified in your testimony that you talked about and gave some more detail on, I think it's the CS. Oh, those are okay. So you addressed 2 of the Cato San Andres unit wells, the 164 and the 150, and those were both force plugging wells, correct?
Those, yes.
Okay. And then the Cole #1 and the Buckskin were both orphan wells?
The coal well, I'm not sure how to define that because that was just an old P&A that, had failed and we had to repair it.
Got it. Okay. And then the Buckskin was an orphan well, right?
Yes.
Okay. In each instance, though none of those wells were recently active producing wells, right?
Cato San Andres wells, I don't know how recently they had produced. But as far as the coal, of course, it stopped producing in 1953, and the Buckskin had been converted to an injection well in 1984, and I don't know when it had stopped being used.
In each case, production was, I mean, can you tell me whether production had stopped for was it more than a year, more than 2 years for each of these wells, or in the case of the Buckskin injection?
I do not know the answer to that.
Okay, so you don't know the time frame between last production or injection for any of the wells that you discussed off the
That
top
is
of your head?
correct. I do not know.
Okay, okay. But based on the condition of the wells, can you tell me whether you think the wells were recently active, or did it appear they were not recently active at all?
Well, the condition varied so much that it's hard to answer that.
Okay. But obviously the well records would tell me, right? If I went and looked them up, how recently they produced or injected, right?
That would be public information, I'm sure.
Yeah, okay. Just based on your experience, Mr. Diede, and all the years you've got and the work you've done with the division over the last year and a half, and your testimony about the wide range of costs incurred by the division to undertake plugging. In particular, I guess the Buckskin was one of the more expensive ones. In your opinion, is an average plugging cost incurred by the division a useful metric given that wide variety, especially in the case of orphan wells?
Objection. Mr. Dees testified to the expense of time and oversight. He's testified that he does not review. He's not responsible for financial records or money costs. We will have witnesses that can address this in more detail.
I remember that.
Well, I guess he's got 50 years experience managing and overseeing plugging, and he's testified about the wide range of experiences and costs that are incurred by the division. I'm wondering, based on his experience and testimony, whether he has an opinion about whether an average cost is a useful metric. I think it's within the scope of his experience and testimony.
All right. Excuse me, Mr. Diede, if you have an answer, go ahead. Otherwise, not.
I hesitate to answer that, so I do not have an answer.
So the reason, I guess, because you talk about in your testimony, you do reference costs, for example, of the Cato San Andres unit wells, but you don't actually provide those costs in your testimony or on your slides, and that's because that wasn't a focus of that's not part of your job description or your purview in your role. Is that right?
That is correct.
Okay. And I think Mr. Suazo asked you about prioritization and how the division prioritizes wells. And I think you answered that. Just to be clear, I think you said that you weren't aware of how wells are prioritized for plugging, right?
That is not an area that I get involved in.
Okay. In your conclusion, you left us with some thoughts. I got this highlighted here that there's, 49,000 or nearly 50,000 wells in the state that are plugged, and an unknown subset of those wells have been inadequately plugged. Do you know if the division has done any sort of analysis to evaluate, based on its experience remediating improperly plugged wells, what fraction or portion of those plugged wells may be an issue?
I don't know how to answer that, but I can say that of all of those wells that were plugged, and we talk about an unknown subset, and it's exactly that, it's unknown. Whether they were adequately or inadequately plugged is to be determined when they fail, and you don't know when that's going to happen either.
So yeah, I guess the more direct or the piece of the question I guess you can tell me yes or no, but you're not aware of any study or analysis that the division's done to kind of try to quantify that to your knowledge, right?
I am not aware of one, whether it existed or not, or exists or not.
I think. On the prioritization question, I think Mr. Suazo asked you who at the division would be able to answer the question about how the division identifies the priority for its plugging, but I don't think you gave him an answer. Do you know who are any of the witnesses slated to testify qualified to answer how the division prioritizes its plugging activities?
I will leave that to someone in OCD management to handle that question.
I guess, yeah, but do you know among the witnesses remaining, if any of those witnesses can answer that question?
I think some of those witnesses can give you some more direction than I can.
Okay, so I'll ask each one in turn and see where I go. Okay, I think, let's make sure I covered everything that you would be able to answer. I think you did, but let me just make sure. And just to make sure I cover this ground, Mr. Diede, I think I understood you to say that, you had some general discussions about applicants' proposed rule, but you yourself haven't reviewed them, so you're not familiar with the way the applicants have defined the term marginal well, correct?
That is correct. I have not been in those discussions, other than I know those discussions have been had, but not by me or not involving me.
Same thing with the term or a well that would qualify as having no beneficial use. You also are not familiar with how that's defined under the proposed rule.
Same answer for that, yes, sir.
Yeah. Okay. So yeah, you couldn't tell me whether any of the wells you discussed today or reviewed for the commission would qualify for any of those categories of wells, right?
I would not be able to tell you that.
Okay. I think that covers my questions. Thank you very much, Madam Hearing Officer. Thank you very much for your time, Mr. Diede. I appreciate it. Thank you.
Thank you.
Thank you. Thank you, Mr. Rankin. Mr. Maxwell, do you have questions of Mr. Diede?
No questions, Your Honor. Thank you.
Thank you. I don't know if Ms. Nanasi is on the platform. No. Mr. Moore? Sheila, can you make sure he can unmute himself? He might be RM right there.
He has permissions to
All right.
unmute.
Mr. Moore? May have stepped away. Ms. Fox or Mr. Tisdale?
Thank you, Madam Hearing Officer. We have just a few. Good afternoon, Mr. Diede. My name is Tanis Fox. I'm a lawyer with Western Environmental Law Center, and I represent applicants in this matter. Thank you very much for your testimony. I just have a few questions. I take it from your testimony that is your primary responsibility with OCD overseeing the plugging and abandonment of orphan wells?
Yes, it is.
And you've been in your position, as Mr. Rankin noted, about a little over a year and a half. Is that correct?
That is correct.
And within that time period, how many orphan wells have you overseen the plugging and abandonment for from beginning to end during that period?
I hesitate to say that I have not been keeping track, to be honest with you. So I don't have a number. It's something I could find, but I don't have it.
Would it, if you can say without guessing, would it be more or less than 20 wells?
Be more than 20, I know that.
Would it be less than 30 wells?
There again, I'm sorry.
If you know,
I can't get that any closer because I have not been tracking them.
Okay. And how many people within OCD have essentially the same job description as you?
Pretty much myself.
Oh.
I'm probably the only one that focuses on this pretty much exclusively.
Okay. Going to the Buckskin number 1 and number 2 wells, I take it from your testimony that there was a big differential between the work done plugging and abandoning those 2 wells, correct?
Yes, as the table shows that the the number 1 well was relatively uneventful.
And I also take it from your testimony that you don't know the precise cost differential between the work between those 2 wells. Is that correct?
Right, that is correct. I do not know.
I note that for Buckskin number 1, the casing depth was about 6,800 feet. And for number 2, the casing depth was about 4,000 feet. Is that correct?
That is correct.
And then I also note that for number 1, the depth reached was about 6,600 feet. And the depth reached for number 2 was about 2,900 feet. Is that correct?
That is also correct.
And what exactly does that mean, depth reached?
That was on the Buckskin number 1. We basically were able to get into the well without any obstructions to very close to the bottom or to a depth at which we needed to begin plugging. So when I say uneventful, we were able to access the wellbore all the way down to where we needed to start plugging. Buckskin number 2, that was not the case. We had many issues as described.
And then I think your testimony was, and please correct me if I'm misstating, was that this is an example where the depth of the well is not correlated very precisely with the technical work that's required to P&A the well or the cost to P&A the well. Is that correct?
Yeah, the difficulty of the plugging operation had nothing to do with the depth of the well on the either one of the Buckskin number 2 relative to the Buckskin number 1.
What were the factors that played into the amount of technical work and cost involved in P&A number 2?
getting some abnormal pressure flows with unexpected, number one, unexpected pressure, and number two, unexpected amount of particulate matter, including rocks up to an inch in diameter, flowing up the casing, which, is just, that's very unusual, very unusual.
In your experience with OCD and your other experience, what factors other than well depth go into the difficulty of plugging a well and the costs for plugging a well?
Primarily, the access to get into the casing would be probably one of the largest factors. Can you pull the tubing, rods, pump, and everything that's in the wellbore? Can you pull those all out without any difficulty and then have full access to the wellbore, regardless of depth? If you can do that successfully, and the conditions of the wellbore, as illustrated in the two Cato San Andres wells, can vary dramatically from well to well in a very short distance on what should be similar wells. So if you can access the wellbore successfully all the way to the bottom, then your chances of successfully completing that P&A operation are pretty much improved.
And then I believe you testified something to the effect of, with regard to the buckskin wells, is that you would have anticipated, given that they were drilled around the same time and in the same location and at about the same depth, that you would have anticipated that the cost to P&A would be similar. Is that a correct recitation of your testimony?
No, I'm not going to testify to cost, but the two wells, the two buckskin wells, given information available prior to the leak that we had on the casing of the buckskin number 2, which was kind of an indication the buckskin number 2 was going to be potentially more challenging than the number 1. I would have, not having known that, I would have expected the number 1 to cost more time than the number 2. That was not the case.
And so would it be fair to say that in certain instances, it would be hard to predict the cost to P&A a well, and you just have to get in there to find out what the work will involve?
Yes, and you have to anticipate, of course. When you write your procedures, you have to anticipate what you think it's going to require. And given the amount of well history information available, you make some determination of what's required when you write your procedure. And then once you open up the wellbore, you'll truly find out what you're dealing with.
Thank you. That's all the questions I have.
Thank you, Ms. Fox. Mr. Tremaine, do you have any redirect?
You just have a couple questions. I'll be brief. Good afternoon, Mr. Diede. You partly answered my first question, so I just want to clarify here. Would you agree that relative to your experience when you worked in industry, that the quality of information about well construction and history available to you at OCD when you were plugging orphan wells is lower than what you would have had in industry?
Yes, that's correct.
Okay. And in your experience prior to OCD, did you experience as high of a rate of tubing or casing failure as you observe in reviewing orphan plugging of wells at OCD?
I think we're almost talking on about two different types of well categories, because most of my experience in working with an operator as a consultant, I was fortunate to be working with an operator that was trying to be proactive and take care of those things before they deteriorated. And I don't think that's the case that we're looking at in orphan wells or possibly even forced plugging wells. I think these have been left to deteriorate longer than what I experienced in industry with the operator.
Thank you. In your experience, if a well has degraded casing or tubing, would it be standard practice to continue producing the well in that condition?
No, you'd have to do a workover of some sort. Depending on what the issue was, you'd have to work it over. And yeah.
Okay. And you received a number of questions about the nature of the examples you provided as extreme examples. Both of those extreme examples that you outlined today, those were both observed during your time working with OCD only in the last 1.5 years, correct?
That's true, a very short period.
Okay. No further redirect. Thank you.
Thank you very much, Mr. Tremaine. Commissioner Ampoma, do you have questions of Mr. Diede?
Yes, very brief. So my first question to you is, what are some of the safety concerns when you visit such a site? Similar to the examples that you shown on your slide number 8, slide number 9, slide number 10. It's so concerning.
I'm sorry, was there a question there?
Okay. Yeah, so can you hear me?
I hear you very well, thank you.
Okay. So and before I ask the question one more time. Thank you for your service, to our state. Now back to my question. So I was asking you on slide number 8, 9, and 10, where you were showing some of the figures of the actual things going on the field. I was asking, what are some of the safety concerns, to you, and then also to even the plugging companies when you go to the site to do this type of job?
Oh, yes, sorry for misunderstanding. Yeah, the safety concerns are a variety of safety concerns. The examples of the unstable environment in the surface ground around the well, that is a major concern because you have to do some remediation before you can safely move in a heavy piece of equipment like the rig. Some of the others, when you actually have the rig in place and you start pulling on the tubing and your casing parts, to me, that's pretty serious because now you have no way to safely keep that well confined. And so that worries me.
Yeah, surely it does. It's also scary when I was seeing all these pictures. So, sir, since you are more or less overseeing the orphan well plugging program, and based on your experience in 1.5 years with OCD, so what are some of the lessons that you've learned from all these wells that has already been plugged? What are some of the lessons that has already been learned to at least guide OCD in moving forward?
Well, first and foremost is be prepared for almost anything. Do not assume that what you think you know about the well is correct. And number two, almost as important, would be to have good communications with your field supervisors that are actually physically looking at and judging those safety concerns real time on site.
My last question to you is, so you talked about on your conclusion slide New Mexico has 49,964 wells within the state that are plugged. Is there anything that OCD is doing in terms of some random monitoring, or is there even any research that is being done or planned to at least minimize the risk, similar to what the extreme case that you presented to us?
I'm not aware of anything that is currently being done in that regard. And like I stated, this was kind of something new to me. I had not experienced this type of P&A failure because I'd never really been working around that many old wells until coming here to OCD.
Thank you, sir, for your testimony, and thank you for being here.
Thank you. Commissioner Bloom, do you have questions of Mr. Diede? Commissioner Bloom may have stepped away.
I'm here. Yes. Thank you, Madam Hearing Officer. Mr. Diede, thank you for your testimony today. Just a few questions. I don't think we're going to need too much time here. Let me pull them up. Mr. Diede, you discussed the coal number 1 well, the COLL number 1, correct?
Yes.
Did you mention that it was leaking H2S?
We did see H2S when our Hobbs supervisor and contractor went to location to check it.
I think the number I'm seeing here was 100 parts per million, correct?
Mm-hmm.
For those that might not be aware, can you explain what H2S is?
Hydrogen sulfide gas is basically poisonous gas. It's something that people that work in the oil field are very familiar with and routinely have training how to understand if it's present, what to do about it if it is. Very poisonous.
Yeah. Does OCD staff in the field wear an H2S monitor or alarm?
I know our inspectors have monitors.
Yeah. How close was this well to that building? It looked pretty
Yeah, it's
nearby.
under. I'm sorry for interrupting. It's under 25 feet from the outbuilding. I don't know the exact footage.
Yeah. So, in your opinion, can wells in need of P&A, plugging and abandonment, threaten human health and the environment?
I think there are many things that can threaten our health and environment, and wells are just one of them. And wells to be plugged, of course, are also one. I don't know how to rank all of those different things and different risks. No.
All right. Well, thank you very much for your time today, Mr. Diede.
Thank you.
I appreciate it.
Thank you, Commissioner Bloom. Chair Chang, do you have questions of Mr. Diede?
I do not.
All righty. Any reason not to excuse Mr. Diede? Thank you so much, Mr. Diede, for your testimony.
Thank you all very much as well. Thanks.
Mr. Tremaine or Mr. Hall?
Thank you, Madam Hearing Officer. At this time, OCD would call John Garcia. He's available remotely.
All right, thank you. See him. Hello, Mr. Garcia. Would you spell your first and last name, please?
Yes, John, and then last name Garcia, Garcia.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Hall.
Thank you. Could you state your name again, please, sir?
John Garcia.
Mr. Garcia, how are you employed?
I work for OCD as the engineering special project supervisor.
Have you, in preparation for this hearing today, have you prepared written testimony to be provided to the commission?
I have.
And is that Exhibit 1 of OCD's exhibits?
It is.
And Exhibit 2, is that a true and correct copy of your resume or curriculum vitae?
It is.
Additionally, have you prepared some slides to assist in your summary of testimony today as Exhibit 3?
I have.
Additionally, have you prepared have you presented 3 spreadsheets to be used in evidence in this matter? That namely Exhibit 17, the master orphan spreadsheet, Exhibit 25, which is well plugging data from 2024, and Exhibit 16, which is fiscal year 2024 production information.
Yes, and just to clarify, Exhibit 17, the master orphan sheet I built and created. Exhibit 16 was partially built by Brandon Powell, who will testify later, but I used some of the data in there to justify some of my slides. So I guess just to clarify, he assisted in that building.
And how about Exhibit 25?
Exhibit 25, sorry, I have my slides in front of me.
I can
Which
pull
one
it
was
up
that?
too. I can pull that up. I believe that's some well plugging information in different categories from 2024.
Correct. That was
that
built
you
by
referred to in your testimony. And thank you for that clarification, Mr. Garcia. Do you adopt and is all the information contained to the best of your knowledge in each of those exhibits correct? Do you have any modification? I'm sorry, go ahead. Correct.
It is, and no modifications.
You have no modifications. Did I hear that correctly?
No modifications.
Okay. Are you prepared to present a summary of your direct testimony to the commission today?
I am.
I would ask you to go ahead and present that. And would you, if you'd like me to share any slides, if you would please just let me know, and I will do my best to do that.
If we could share the slides so I can see them, and I guess before we get started, can you hear me correct? Okay.
Yes. Can you see that, Mr. Garcia?
I can.
Okay, great. If you would please present a summary of your testimony. Thank you.
Yeah. I'll start off. Prior to this slide, my testimony includes my written testimony, which I will summarize today. In addition, it's my resume and experience. I'll summarize that briefly. I came to OCD December 2019 as a petroleum specialist. I worked in the admin team, processing APDs, plugging sundries, drilling sundries, pretty much any submission that OCD receives. In 2023, January, I was promoted to the engineering supervisor of the special projects. My roles and responsibilities with that, it's a special projects team, so the roles vary. We encounter hearings for OCD and the orphan plugging, of course. The master orphan spreadsheet got some attention today. I'll talk about how we built it. Originally, I was tasked by my management to build this Excel sheet. As when I first entered the program, there was a number of places, whether it was OCD's website or various Excel sheets, that management was having to pull data from to keep their reporting to whoever was accurate, whether that was the federal or state government. I was tasked by my managers, Brandon Pell, to be specific, to build a database for them to use efficiently. I met with multiple teams, stakeholder meetings. It took quite a while to build and pull lots of data. A lot of the data was built by me reading and interpreting hearing orders, with legal vetting my reading interpretation of those orders to get wells into the Excel sheet. We then built it into, you'll see the color scheme. It's not showing on the screen, but there's a color scheme built into it where there's like a black color, red color, etc. Those colors were built for management to have a clear, concise person of who they could contact responsible for that data. For example, engineering is dark blue. That's mine and Loren's database that we're responsible for on a day-to-day operation level. That list contains about 1,800 wells, as people have talked about. I think that's about it for that slide. This graph was built just to show some of the numbers of wells that are plugged in the state of New Mexico. OCD plugged 100 wells in the calendar year 2024. Forced plugging, same definitions that Loren used, was 129. Industry plugged 773 wells. This data was used by sundries that were submitted to OCD, subsequent plugin sundries. If you can find OCD and forced pluggings, about 23% of the wells plugged were orphan. If you don't want to count forced plugging as OCD, about 10% were orphan plugging. I believe that's it on this slide. This graph was built by me to try to show the commission if the petition was adopted, how many wells it could potentially affect. I will note there was some confusion internally with OCD. Specifically, I had some confusion with it as well in the original petition on the reading of it. There was some confusion on if the petition was supposed to be and or was it supposed to be interpreted as or. So for example, was it 180 days and 1,000 BOE, or was it 180 days or 1,000 BOE for marginal wells? I chose to use the word or in the code because it showed the more severe consequence of the rule if adopted. So the commission can have a, I guess, worst case scenario mindset on it when they're reviewing it. And basically this graph shows 33,000 plus productive wells, which are wells that didn't fall into the categories. That was the definition I came up with. It was not in the petition. Marginal, inactive, and no beneficial use were the definitions in the petition by the applicants. But again, I use the word or in the code. So if a well hit 90 days or 90 BOE, it fell into the no beneficial use category. I think that's about it in this well. The following slides are, they're wells that I picked. There's no specific reasons these wells were picked other than they're good examples on some of the confusion that existed with me and to show the commission the difference of BOE and the days produced. For example, the Electra Federal number 22, we can see the last few years of its production history, and we can also see the last few years of the days it reported production. This is all operator provided data to OCD. This graph is simply just showing us the BOE versus days comparison. If we can go to the next slide, I think there's a more refined view of it. So it's still the Electra Federal well, but it's zoomed in on the BOEs, and it also drops the day count. So the black line on the left that's crossing through the data is a indication marker of where the 1,000 BOE threshold is. Using the or mindset, this well would be marginal, even though it had the 350 give or take days reported production every year. The last 2 years, it has fallen below the 1,000 BOEs for various reasons. So this is just an example of a well that became marginal. If you took the production by the year, it was less than 1 BOE per day, just showing that this well was showing signs of having some sort of problem. Next slide, please. Similar, I think the well name got cut off on my side. The Eubank Spencom well, similar example. It's just another well to show the difference in BOE versus days. This well we can see has a normal decline curve. The last few years, the production's been overall kind of stable. It has been under that 90 BOE for this well. However, this well I use just to show the fluctuation in days that it's been producing over the last 20 years or so, since 2006. Some years it's produced every day of the year. Some years it's barely produced on a day count. The BOE doesn't really reflect that here as much, but it's just showing a difference between BOEs and day fluctuations. I think the next slide is also zoomed in. Same items, just a zoomed in version of the previous graph on the last 10 years of production. 8 of the last 10 years, this well has been below the 90 BOE. Again, with the mindset of, or this well would have been no beneficial. 8 of the last 10 years. This well is drilled in 2005 to about 4,500 feet. I'll note this well has been sold 3 times since 2016. I do not have the exact names it was sold to. They're public record, but it has been sold 3 times. And then the last well, the Rock Queen, similar mindset, kind of showing the difference in well to well. This well is an older well, 1993 is the earliest production OCD has on it. The production looks skewed because they had a few good years in 2015 and 16, which really brought production up, but it had consistent production from 1993 onward. The days of production were fluctuating during the same time periods. I'm assuming the operator did some sort of workover or recomplete on it, and production came up, and the days still are fluctuating even though BOE was coming up. And that's just a graph showing the difference in days as well. Same well, just a more refined in view of the days and the BOEs overlaid on each other, with the 90 BOE threshold labeled as that red line. This well has been sold 9 times since it was spud in 1955, which is quite a long life for a well. It has a lot of selling to go along with it. It was recently sold in 2024. And I'll note we have had very little production on this well since the selling. This is my last slide, and basically there were some questions to Loren about who wells he used as examples of OCD's plugging efforts. These are the same wells that Loren discussed. You'll notice the Cato San Andres 150 and 164 on the left-hand side. This shows some of the questions he was asked earlier about how many times was that well sold. I do not have the last day they produced on here, but they are public records. Both of these wells follow a similar lifespan, just like they did drilling. They were drilled in 1967, sold to Sierra in 1995, again in 1999 and 2007. They became an orphan well under order R-14795A. And as Loren discussed, they were plugged by Shell Oil Company. The Cole well and the Buckskin well, as Loren also discussed, these are just showing the same history for these wells, how many times they were sold or divested. It was drilled by Olson Company. It was sold to R. Olson in 1954. And then it was originally plugged by Gel Oil Company in 1960. Our records are a little unclear there of why the operator didn't plug that well. But then again, obviously it was replugged by OCD recently. The Buckskin, which was our well that Loren discussed, was drilled by Lenexco in 1980. It was sold to another entity of Lenexco, DBA, New Mexico. It was sold again to Energy Acumen in 2022. There was an NOV against Lenexco, and when it was sold, they were subject to an ACOI, or a settlement agreement, with Energy Acumen. Energy Acumen failed to follow that, and OCD plugged this well. And I believe that concludes my testimony.
Thank you, Mr. Garcia. At this time, OCD would move would offer and ask for admission of exhibits 1, 2, 3, 7, 16, 17, and 25.
We'll be cross-examining Mr. Garcia about that.
All right. Are there other objections aside from Mr. Cloutier's objection to 16? Pause for a moment.
No, Namoga will object to 16 also pending the outcome of that cross-examination from Mr. Cloutier, but no objections otherwise.
All right, so exhibits 1, 2, 3, 17, and 25 are admitted, and we will resume our discussion later of exhibit 16. Mr. Cloutier, are you going to begin our cross-examination.
I will do so, Madam Hearing Officer. Mr. Everhart, if I could switch places with you. If Ms. Trump could get screen sharing authority, please, Ms. Evans. Okay. And if I could ask.
I believe I have it. Yes.
Thank you. And we filed and served on all parties certain demonstratives. We were up late last night building and
I think they are, but I don't know. Yeah.
So you should be seeing IPNM demonstrative Garcia is the header.
I do.
we've got it. Thank you.
Madam Hearing Officer, we have some objections to both of these exhibits. If this is premature, that's fine, or if you would like us to, we can lodge those objections at this time.
We're not admitting these exhibits here. We're using them as demonstrative right now, and we'll provide testimony on them later.
All right.
May I present my objections, including based upon that basis?
Yes, present your objection. We may or may not talk about it right now, but go ahead.
Very well, thank you. We have three general objections. The main one being the timeliness. There was a deadline of October 15th to file demonstrative exhibits at 5 p.m. While these came at 8:06 this morning, less than 1 hour before the hearing started. Additionally, related to that, Mr. Garcia has not had very much time to review that or analyze it, internalize that. Also, these mischaracterize and alter an exhibit that has been admitted in evidence.
All right, thank you for that. Let's proceed through the cross-examination, and just a caution for Mr. Garcia. Mr. Garcia, if you feel that you are unable to answer a question or questions based on a lack of time to review these, just say so.
Understood.
Go ahead, Mr. Cloutier.
Thank you. Mr. Garcia, my name's Andrew Cloutier. I represent IPA&M. I do want to thank you for your public service. Industry and the regulators sometimes row their oars in the same direction and sometimes don't, and this is one of the times we don't. I've got up your direct testimony that you submitted, correct?
Correct.
And you described the creation of Exhibit 16 as using, in the second sentence of the paragraph that we've got up there, applying is my word, I quote now, a simple if/or script was programmed into the Excel spreadsheet to return the category title based on the parameters set in the petition. Did I read that correctly?
Correct.
And you tell the commission in your direct written testimony, those parameters are defined in the petition, correct?
Correct.
And it says, as, and I quote, marginal well, close quote, which means an oil or gas well that produced less than 180 days and less than 180 barrels of oil equivalent within a consecutive 12-month period, correct? That's your direct testimony?
Correct. 180 days and 1,000 barrels of oil equivalent.
And that was your direct testimony with the word and in between the two parameters, correct?
This was a copy and paste from the petition, but yes, the word and is present.
All right. And you have told us today, after I submitted our demonstratives, that in fact, the word or was used when you created OCD Exhibit 16 for marginal wells, correct?
Correct. Again, there was some confusion on the interpretation of the petition, so I chose or based on direction from my management and legal counsel.
Okay. Which management directed you?
Brandon Powell, who will speak later, can probably talk more about it. I will know, I believe since I built that exhibit, I believe the parties have had more discussion on that, which Brandon may discuss later. Again, I'm not offering an opinion on the rule, just more of here's what the most substantial effects of this rule could be. And or is the more substantial effects.
Correct. But in your written testimony, you told the commission, you told the parties that you used the word "and" incorrect in doing this, correct?
As the petition defines, yes.
And that was when you wrote your direct testimony after using the script that you use, you incorrectly described the script here in your direct testimony, didn't you?
I would disagree. I would, again, say there was some confusion on how you would read and interpret the rule on a broad basis. And it was confusing if OCD wanted the word or and. And again, per direction from my management, we use the word or. So I would say the statement's true in my testimony is here's what the petition outlines and how the code worked based off our interpretation of the rule.
You tell us that you did it based on the parameters set in the petition, and the petition says, and between the two categories or two issues in marginal well. And in fact, the script said or, and all the data in Exhibit 16 was based on or, not and, correct?
I still stand by my statement. I think we're going in circles. My line 5 says, and if or script was programmed. So I wasn't trying to, catch anyone off guard. I said I used the word or based on the petition, which was copy and pasted below, because there was some confusion on an interpretation of the petition.
I understand confusion. There's a possibility of confusion with the petition, but were you confused when you signed your direct testimony as to whether you used the word or and when you prepared Exhibit 16?
I used the word or, and that's what I signed.
What did you sign that used the word or?
The exhibits would include the code.
Okay, and the exhibits 16 and 17 did not include the script in it, did it?
Exhibits 16 and 17 did not. Historically, codes tend to get broken the more they're shared. And so it showed the results of the code, but the code was provided to IPEM per their request.
I agree. And the next page of that will show you. In fact, why don't we go to the next page of very briefly. We had a heck of a time recreating Exhibit 16 from the data, and I finally asked your counsel if we could have the if-or script. And I asked last week, and I don't think unpromptly, but after October 15th, we were provided the script, and this sets forth.
Objection to the sidebar on the testimony from Mr. Cloutier.
Mr. Cloutier, please get to your point here.
This is us being provided with the script, correct, Mr. Garcia? Monday, October 20.
According to what you're screen sharing, that's the day our counsel sent it to you.
Okay. Are you aware of any of the parties, industry parties to this rulemaking getting this script before October 20?
Not to my knowledge.
All right. Thank you. Go back to page 1, please, Ms. Tripp. And on the no beneficial use thing, we have the same and or issue. You use the word for at least 90 days and has not produced at least 90 barrels of oil equivalent in your testimony that was written, sworn, and submitted to the commission, correct?
Correct.
And in fact, when you created Exhibit 16, you used the word or, not and, in writing the script, correct?
Again, correct.
All right. And where in your testimony did you advise the commission or any of the parties to this rulemaking that Exhibit 16 was in fact a worst case scenario, not the parameters set forth in the petition and the proposed rulemaking?
Again, Exhibit 16 just shows how OCD was interpreting this petition, and there was confusion. And per directive, this is what we built to give the commission their mindset of what this could affect. It was our interpretation of the rule. I think we've seen a lot in this hearing that data can be taken in different ways, and this is how we interpreted the data.
Okay. All right. We've done the second page. Ms. Tripp, so if we can go to the third page. This is a page that we prepared last night after finally sorting out this script and served this morning. It's Exhibit 16 with the script that you wrote up top, correct?
I will note you guys caught it, I believe, but there's a missing parentheses, which I think I got lost in transit to you guys between the first or and H2.
Okay.
But
and
other than that, it's pretty accurate.
There was a missing parentheses there, correct? But that didn't affect the numbers either, did it?
One to the right. If it ran without the parentheses, it would probably have caused issues, but
okay.
No,
Why don't we go to the second? Why don't we go to the next page, Ms. Tripp, since that's what Mr. Garcia is talking about. So we fixed essentially two things that were not completely proper here, and one of them is the parentheses that you're talking about, but it didn't, in our analysis, did not change the numbers in Exhibit 16 when we ran this script.
Once again, object to Mr. Cloutier's testimony. I would ask that he ask Mr. Garcia a question instead of testifying.
With these corrections, do the numbers change on Exhibit 16? Were you able to run the corrected script, Mr. Garcia?
I have not.
Okay. All right. Let's go to the next page, Ms. Tripp. Now, correction number 2 that are labeled here is changing before the word. Well, let me talk about this script here. There's the IFS, correct? And do you understand that to be a command that if it meets one of the categories in the sequential order, then you stop because you've categorized the well? Is that your understanding of how the script works?
Correct. Ifs is a chunk statement, is what I refer to it as. It reads the first chunk of information and proceeds to the next one, depending on if it was a true or false result.
Okay. And for the definition of inactive, which follows the parentheses here, you have asked the script to label as inactive if something in H2 of the Excel spreadsheet or L2 spreadsheet is 0. Is that correct?
Objection. Mr. Garcia did not compile this document. Mr. Cloutier did. So his characterization of you doing this would be misleading.
In anything in the red, I'm talking about the work that he did, which is what he did here, correct?
That's how I understand.
That's what you did, was use script that was intended to, if H2 or L2 equals 0, the well should be labeled as inactive. Is that how you understand the script that you wrote?
To clarify, if we're looking at Exhibit 16, H2 and L2, column H is days, column L is BOEs, L2 is the row number we're on, and so is H2. So H and L, what this code is saying is if days equals 0 or BOE equals 0, label it as inactive.
Okay. And this page that I'm showing you for no beneficial use, we have changed from and to or. You had it or if either the days were less than 90 or the BOE was less than 90 in H2 and L2, it should be defined as no beneficial use.
Again, if you want to change how you interpret the original petition to and, you could change the or to and it would result in different numbers because you changed the parameters and data it was fed.
Okay, Ms. Tripp, why don't we pull up the original petition beneficial use for a moment if we could?
Yes, it'll take me just a second because I have the
Yes.
amended version.
Thank you.
Let me stop sharing. You should now be seeing the application that was filed June 25th, 2024.
If you could go down to 1915-25 9A.
What, 9A?
No, it's way down there. It's not in the definitions.
Oh, okay, got it. Sorry about that.
Presumption of non-beneficial use.
Uh,
1525. Sorry, did I write it down? You do a control F for beneficial. There we go. Nope. Next
hold on.
one. Keep going.
It's only 20.
I know. Then
Nope.
3 more.
Could I ask a clarifying question while you're searching
Sure.
through that for a second? I believe my printed materials here may have numbering of exhibits that might be slightly different than yours, and you refer to exhibit 16 is what you're trying to cross on. Can you give me the title of that document? Because what I'm looking at doesn't seem to track
Exhibit
with what you're
16
talking about.
was the slide that Mr. Garcia showed us, OCD. Exhibit 16, which was a pie chart that was in his.
In his
Presentation.
demonstrative, it's a pie chart. Exhibit 16 is actually an Excel spreadsheet.
Okay. The demonstrative was the pie chart.
Okay, but the pie chart is, okay, I have it as a slide in exhibit 3 then, is that correct? Okay.
That is correct here.
Okay.
Now we're on the same page. Thank you.
Yep. Thank you.
Okay.
Mr. Garcia, what you're saying though is that you were confused by the words and or, and you used or in the script twice where the petition actually uses the word and, correct?
Objection asked and answered 4 times.
Yeah, Mr. Cloutier, he has answered this quite a few
Okay.
times.
Mr. Garcia, do you agree that using the word or in the script for no beneficial use wells instead of and would overstate the number of wells for which there would be a presumption of non-beneficial use?
I would say using the word or would show, again, I'm not offering an opinion on the rule. The word or would show the commission when they're evaluating this case between the parties on the more substantial effect it would have against industry. And it would show the more burden it would provide industry, using the word and would lighten the numbers and lighten the burden that industry would be under if you use the word and instead of or with this proposed rule.
Well, if you use the word or, you capture a group of wells that, for instance, might have produced more than 90 days, but produced less than 90 BOE, correct? For no beneficial use?
Please repeat it, your question.
Yes. If you use the word or instead of and, Exhibit 3 would calculate as would show as no beneficial use, for instance, a well that produced more than 90 days, but less than 90 BOE, correct?
Correct, because it's looking for either or.
Right. And the same for marginal. If you use the word or, you're looking at a well that it could include wells that have more than 180 days production, but produce less than 1,000 BOE, correct?
I can answer that question, but just for me, could we keep that slide that was just shown back up?
Sure. Ms. Tripp?
Sorry, I like
Sharing?
numbers.
Yes.
We lost the visual.
Can you see it now?
Yes.
I can. Okay, could you repeat the question? Sorry.
Sure. So we're looking on the second line. You've got a formula for marginal. In red, we have the word and, you had the word or there, correct?
Correct.
And by perfect, you mean yes, correct?
Correct. I said sorry.
Yep, that's all right. Just want to be clear. And when you use the word or, you would
Sorry about this.
please, when you use the word or, you could capture a well that produced less than 180 days, which is part of the definition of marginal rule, but more than 1,000 BOE, correct?
My general statement, I guess, on this code that we're seeing here, the more I'm looking at this would be, I would heavily caution saying anything against this code. The edits you made actually seem to break the code because your graph below, you're showing nearly 1,000 wells that are in the NA category, which means the code didn't know what to do with 1,000 wells.
Okay.
And I'm assuming why it's doing that is because there are a lot of wells in this data sheet that have 0 days produced, but they show BOEs, and they have the opposite too. They have BOE, but 0 days produced. So I'd be hesitant to say wells are being categorized correctly here.
I think you agreed with the parentheses there, and we did not change the word or in your code. We just put the parentheses there for inactive, which is what you're using, correct?
Objection to Mr. Cloutier's testimony once again. He should ask questions instead of characterizing the evidence.
Well, he's just told me that the code we're showing is wrong for the word inactive, and I'm just asking him if all we did was add a parentheses, which he agreed to at the outset of his testimony.
Right. He asked him to agree, whether he agrees.
The code that is being displayed on my screen has multiple red things edited. With all those red edits, the code has seemed to break because you have 954s uncategorized. So I'm hesitant to say you're changing of just the or on negative effects, where marginal effects on this code.
But my question, Mr. Garcia, was not whether the code was broken or whether you agree with the code. My question was, if when you're searching and classifying a well as marginal, you use the word or, you would pick up wells, for instance, that produced less than 180 days, but produced more than 1,000 BOE, and classify those wells as marginal, correct?
Correct. I believe I've been very open about that and using the electric well as an example of confusing and issues that the rule could face. The Electra well showed the 350-day production consistently with less BOEs. And again, that's what I discussed that slide about. about how the confusion of this could be taken.
Okay. And so what you're telling us is that internally at the Oil Conservation Division, you knew that Exhibit 3 and Exhibit 16 were run with script that used the word or, but when you signed your testimony, you used the word and in both your definitions of marginal and no beneficial use. Correct?
Again, my testimony says I used an if or statement, which is true and correct. The definitions were copy and pasted out of the petition, and the if or was based on our interpretation and reading of those definitions. Those definitions are not mine. They were copy and pasted.
So can we go back to the testimony, please, Ms. Tripp? So what you're telling us is that we should have realized with the statement if or in the third sentence of this paragraph that you did not use the category title based on the parameters set in the petition like you say later in the same sentence. You in fact did not use the word and substituted or for it, correct?
I don't understand the question again.
Sure. Sure. You say at the end of the sentence that whatever you did was, quote, to return the category title based on the parameters set in the petition, correct?
Correct.
And what you're telling us now is by using the phrase simple if or script, everyone should have known that you were using the word or instead of and when you wrote the script.
I can't testify to what everyone should have known by reading that. I don't know everyone's comfort level with Excel.
Was that your intention in writing and signing as true and accurate this sentence?
The sentence shows how the Excel was built with the if or script based on our interpretation of the petition.
And then your interpretation of the petition is in the if or script. And then in the immediately preceding next two sentences, you demonstrate your understanding as of the date you signed your testimony that the petition used the word and in both the marginal well and no beneficial use definition, correct?
But again, yes, correct. I think we covered that.
Would you agree that there is no statement in your testimony that the exhibits, your running of script through Exhibit 16 was meant to show a worst case scenario, not what the rule actually would have resulted in?
The words worst case do not appear in this. Well, worst case staring on the screen.
And is there any affirmative statement in your testimony that the script that you ran through Exhibit 16 would not reveal to the readers and, well, let's read the bottom of the sentence. You tell everyone that based on that, looking at the data for 2024, running it the way you did, it shows based on the petition, OCD would have 33,211 wells deemed productive, which are not in a petition category, 11,499 wells deemed marginal, 6,400 wells deemed inactive, and 4,380 deemed as no beneficial use, correct?
Again, correct. The results are based on OCD's interpretation and directive from my management who was in more meetings and discussions about the rule and meanings behind the rule than I was. So I relied on my management on their interpretation and trusted them. And based off my knowledge of my discussions, the word or was what was to be used. So those numbers are correct.
When you use the word or in the definition of marginal and no beneficial use, those numbers are correct. Is that your testimony?
Off OCD's original interpretation of it.
Yes. And there is at least the potential that they're incorrect if you use the word and.
I think if you change mindsets, anything would change.
All right. And you did this at the direction of management.
Correct. Who I'm assuming would probably cover any other questions on it.
Okay.
As well.
Wow. Interesting. Okay. We object to admitting anything to do with Exhibit 16, Madam Hearing Officer, as the data is being presented as if it's consistent with the petition, and it clearly is not.
Mr. Hall?
Yes, Exhibit 16 has nothing to do with this line of questioning, in my opinion. It's not where the script went in. I think he's referring to a pie graph maybe in a different exhibit. Exhibit 16 should come in.
And we object to the admission of the pie chart as well.
So the pie chart, I think, was part of Exhibit 3. Is that true?
Page 4 of Exhibit 3, is that correct?
Yes.
And I'm happy to respond to that. I don't want, if it's premature, I can wait.
Go ahead.
That exhibit speaks for itself based upon Mr. Garcia's testimony of how he input the data and the code. They are free to make their own, everyone's free here is free to make their own conclusions from that, and his testimony associated does not make it inadmissible.
And Exhibit 16 also, Madam Hearing Officer, actually contains the affirmative categories that resulted from the script that Mr. Garcia ran through it. So it categorizes wells as non-beneficial use or inactive or marginal based on the script that he ran, not on the petition.
All right. So, Mr. Hall, would you like to address that? I'm looking at 16, which is
Sure. The same. Mr. Garcia has not hidden anything, as Mr. Cloutier is at least implying. He has testified forthrightly about the inputs he put in. He has subjected himself to cross-examination. The commission is certainly free to draw whatever conclusions from the results based upon the inputs that he has been an open book about how he put them in. That doesn't make it inadmissible.
all right. Mr. Suazo, you have anything to add?
No, Madam Hearing Officer.
Mr. Rankin?
Maybe I'm just wondering. I think looking at Exhibit 16 and understanding, I think what happened, 16 is confusing, and it does not seem to align with the petition. So I'm wondering if there's an opportunity just to, and I don't know, but just to have Mr. Garcia do it again. I think it'd be useful to see what the division's understanding of the rule is and how it breaks out in the data. I haven't talked with anybody else about this, but I just, it is misleading. I don't understand. It seems to not accurately reflect what the petition says. So I don't know that the utility would serve to admit it. But anyway, so my suggestion is maybe to withdraw it and see if it can be done again with the opportunity for council to review it and cross again on that issue.
Madam Hearing Officer, this is Jesse Train, if I may. Brandon Powell will be able to speak to this. John Garcia did not generate Exhibit 16. That was a data pull. And John Garcia, and I believe he did clarify and testify to this, that he used Exhibit 16 and applied a script to Exhibit 16 or the underlying Excel sheet for 16 to generate the information that he included in the pie chart. So there is additional foundation that can be laid here, but as the foundational data that Mr. Garcia used, Exhibit 16 is not objectionable.
Okay. Anything further, Mr. Cloutier?
I would just say then I'm not sure why Exhibit 16 is being tendered through Mr. Garcia if he's not the one who can lay the foundation for it.
As I understood Mr. Tremaine just now, it's because he used it to create the pie chart.
So I still object to its admission, and I object to the admission of page 4 of Exhibit 3.
All right. So I'm sorry, who said something?
May I ask a clarifying question? Is there, so I understand the pie chart part. And in your demonstrative, there was extensive discussion of the lines of code. Looking at my printout of Exhibit 16, which of course doesn't show any code, what column exactly is the column at issue, or which columns are at issue? Could you just put that into the, or, just for the record, so we're all on the same page?
Ms. Tripp, can you pull that up for me? I don't have it up and don't seem to be connected to Wi-Fi.
Yes, just note that it's a large file, so it's taking me a second.
All right.
Madam Hearing Officer.
Mr. Tisdale.
Yeah, appreciate Mr. Rankin's suggestion that we have OCD run those numbers again. I would just say Mr. Purvis did do something very similar to this in applicant's Exhibit 40. That was the scatter plot that showed no beneficial use marginal wells that has been admitted into evidence and could just be used as a replacement for Exhibit 16.
All right. It seems to me that we might want to talk again about Exhibit 16 when Mr. Powell is testifying. So let's hold off on the admission of 16. I do understand, though, that Mr. Garcia prepared Exhibit 3 and the pie chart in Exhibit 3.
Yep.
Oh. All right.
And I'm going to talk about pages 5 and 6 of Exhibit 3 as well with Mr. Garcia with time remaining.
Okay, I think we've already admitted 3.
Okay.
We have. So let's hold off on 16 and perhaps the division, the applicants can talk about whether it is worthwhile to file another 16. We do still have plenty of hearing days left and time to explore this topic further. So let's hold off on the admission of 16. Mr. Cloutier?
What's my time, Madam Hearing Officer?
Hold on 1 second. So you would have had, let's see here, another 15 minutes or so, but we'll add some minutes for our discussion just now.
Madam Hearing Officer, may I just interject a concern about what I see happening a little bit here, and I just want to raise it so it's not last minute if it comes up again. I see a lot of stuff getting shifted over to Mr. Powell, and I just am a little worried about being able to go through everything with Mr. Powell. So I just want to raise that issue. We each only have a certain amount of time, and there's a lot of material to review: bonding, financial assurance, the language of the rule, division's authority, a lot of material. And I do have a little concern about it all getting bumped down to Mr. Powell, and we only have a certain amount of time to review all that with one witness.
All right. When we get to Mr. Powell, if you want to bring that up again, we can talk about it again.
Madam Hearing Officer, if I may, it
Yes.
might be a good thing for us to take up at a different time, but probably before we start preparing or finalizing our cross-examination for Mr. Powell, because it will make a difference to us,
Okay.
all of us, if you don't mind.
All right. So we're not going to get to Mr. Powell today. I'm just certain of it. Let's talk about this tomorrow. So let's see. should we take perhaps a 10-minute break and then you can resume with your last 15 minutes of questions?
Thank you, Madam Hearing Officer. That'll
right.
be fine.
Mr. Garcia, can you face your mic a little bit more when you're talking to the witness?
I'm sorry, what was that?
Can you face your mic a little bit more because you're a little fuzzy?
I can't fix my mic because it's one of those like phone transmitting mics.
Oh, okay.
I can try to swap to a different one. I would have to go get it
I mean,
though.
that's better. It seems when your face is up, it's clearer, but when you look down or looking at a document, you're a little fuzzy.
Okay, I will try not to do that.
Thank you.
Clarification.
All right, Mr. Cloutier.
Thank you, Madam Hearing Officer. Mr. Garcia, you ready to go back?
Yes, sir.
Going to switch topics to, let's pull up OCD Exhibit 17 first, please.
I can see it.
Okay, and this is the master orphan spreadsheet that you testified you created, correct?
Yes, sir.
All right, and this exhibit cuts off on what column, please, Ms. Tripp? Cuts off over here in the, no, is this 55 or, yeah, this is Welk Exhibit 55. Okay, so Welk Exhibit 55, let's go back to the far left-hand side then. Sorry, Ms. Tripp, I miscommunicated with you about which one I wanted up first. What does the words in column C, plugged, site released, mean, for instance, as we see in line 10 next to the Sibley Jennings federal number 2?
Okay. Plug site released in general for OCD is a term given to a well after the well has been plugged and OCD has approved the plugging. And depending on the well type, is it federal or state? If it's a state well, the OCD has been to the site and our inspectors have been to it and they're happy with the site, the way it looks, trash spills, etc. We can plug site release it. If it's a federal site, OCD only plugs the well, and then our database basically automatically puts it in site released. As it is assumed, BLM will be handling any site cleanup.
Okay, and down below that, Mr. Garcia, I think the first instance, if I'm looking at it, is in line 19, the Tolmac state number 2. We've got plugged, not released. What does that mean?
Correct. Something very similar. Basically, plug not released means OCD has, or an operator or OCD, whoever is plugging the well, has plugged the actual well bore, and OCD has approved that plugging. But the site has either not been inspected for state wells, or it could have been rejected due to environmental factors, etc. There could be a number of reasons it was rejected, but basically it's pending site inspection and site clearance.
Okay. All right. So it might be as far as in order to have the word plugged there in column C, whether it's site released or not released, that means the plugging work has been done and OCD has approved that plugging work, correct?
Of the physical wellbore, correct.
Right. And up to top, lines 4 through 8, it looks like we've got some Lansford wells that look like they're owned and operated by Energy Acumen, correct?
Correct. That's what this shows.
Okay, and they show as active, correct? In their status column, column C?
Correct.
Yep. And if we scroll over to the columns BI, BK, please, Ms. Tripp. Slow. So for these particular wells, we've got actual plugging cost figures, correct?
But that's what the Excel sheet has, correct?
Yes, and as far as you maintain it to be an accurate representation of OCD's data, correct, Mr. Garcia?
I would agree with that, and just note, I talked about testifying earlier and I didn't have it up, but since you do the colors, I'll note too, just like line 1, we can see in the purple, it says projects team. It has Jim's name listed there with along a few others. Those are the people responsible for this data. But according to what OCD provides you, this is the data we had at that time. Now, if that team has revised it anyway, I cannot say if that's true or not.
Well, yeah, thank you. And that's a good correction. So other people have access to different portions of this spreadsheet. For instance, if we keep going, I don't want to miss Tripp, but if we were to keep going to the right, there's a yellow section dealing with bonding. And what you're telling me is somebody else within the division has responsible for that yellow section, for instance, correct?
Correct. Again, not to go to my testimony, but I built this with a lot of team stakeholder, and the colors basically represent those stakeholder and those team engagements and what they were deemed important by their teams to be included in this master Excel sheet.
Okay. And just, I want to be clear for the Lansford wells here, since it appears from the purple, you would agree with me that if you were to read for the Lansford wells and you were to see these actual plugging costs, that would indicate to you that plugging activity has at least started on these wells, if not been completed. Would that be a fair interpretation?
I would assume based off the dollars and the actual plugging cost work has taken place or began.
And you, John Garcia, would be relying on somebody else within the division, in this case, the special projects area, to have accurately put that data in. You wouldn't know one way or the other, correct?
Correct. And just to clarify, the special projects team, I'm engineering special projects. I do engineering, special projects. There's also a division-wide special projects team, which Jim oversees. And his team's responsible for this data, not to confuse people.
I appreciate the clarification, Mr. Garcia, and I apologize if I did not intend to misstate. So with the Lansford wells being active, that would suggest to you in your part of the spreadsheet that at least you have not gotten word that an inspector has gone out and inspected and approved the plugging. Is that a fair statement?
I would not rely on column C. I would scroll over to the dark blue and the light blue. The dark blue is my responsibilities, which talks about if sundries have been submitted and approved. The light blue is our inspections team that would tell me if someone's been on site, yes or no.
Okay, let's tell me where to stop. Okay, there's light blue is right over there. Just a little bit further to the right. There we go.
Correct. Yeah. So our inspector supervisors are responsible for going out on site, seeing if it's approvable or not. I will note on the dark blue to the left, we saw that it said rejected. So that's why these are still in active status. Is Loren, when reviewing them, rejected the sundries. Therefore, the well bore's approval is not done, hence the active status still.
Okay. So work has been done on these, and I'm just asking these questions because I was a little confused as to why I was seeing plugging costs and all that. And you've assisted me in understanding that. So thank you, Mr. Garcia. Now, I take it from your direct testimony, you don't have anything to do with OCD Exhibit 29, the financial assurances report?
I do not.
Okay. And you wouldn't be the right person to ask any questions about that, correct?
Not on financial assurance.
Thank you. Yep. Okay. Can we go back to Exhibit 3, the slides, and page 5 and 6, please, Ms. Tripp? And did you see the rebuttal testimony submitted by Mr. John Neighbors of Spur?
I did.
Okay. And Spur is you understand Spur to be the operator of this well, the Electra Federal 22?
Correct.
And Mr. Neighbors basically stated, which I think these visuals show as well, that yes, indeed, the well produced less than the 1,000 BOE as provided in the definition, but for all dates, it produced more than 180 days during the year, correct?
Correct. That's what this shows.
And in Exhibit 3, you categorized the Electra Federal number 22 well here as marginal because you were using the or rather than the and. Did I understand your direct testimony to that correctly? Okay. So this would not be a representation to the commission as to a potential marginal well under the petition as it stands with the word and in it. Would you agree with me there?
Yeah, and if I may, I guess I would say between my testimony and Mr. Neighbors, there's nothing wrong in his testimony, and I've read it. He talks about how Spur interprets the word and therefore this wouldn't be. I think my general statement was and is to the commission and to the parties is the overall arching rule just needs to be clear and concise for all the parties so there's no confusion on wells like this. Mr. Neighbors talked about why this well had it. I think just a clear, concise rule, if approved, is what we're seeking.
Okay. But the rule in its current format is confusing to you, correct?
Yeah, I think we established that. But, by reading Mr. Neighbors' testimony, using the word and this word and the way he interpreted in his testimony or his rebuttal testimony to me, I see where he's coming from, and it wouldn't be marginal based on the way he interpreted the petition.
Yep. And Mr. Neighbors testifies about the constrained takeaway problems for gas for this well. Did you read that testimony?
If I remember correct, I believe he said there were some tubing issues with this well, and there was some cost, give or take, $60,000, and then he had some other issues with takeaway. I believe those were the issues he stated.
Yep. And are you familiar enough to know that it's difficult to produce into a higher pressure gas transmission line and impossible to produce into a gas transmission line that the owner shuts down?
Yeah, I mean, if you can't meet your pressure to get into it, you're physically never going to get into it because of pressure deltas.
Right. And sometimes systems are down for repair and you can't get into it regardless, correct?
Yeah, I mean, oil and gas has a bunch of issues they encounter.
Okay, good. And do you understand the rulemaking to be proposed to give operators a break on marginal or no beneficial use status if there's something in the gathering system that prevents them from producing the well?
I wouldn't say I'm an expert in the full petition that was written. I've read the original petition. I think it's been revised a few times, kind of my understanding. Tried keeping up with all the exhibits. There's a lot in this case.
Okay.
But I don't know if it specifically calls out. I couldn't testify to that, any breaks it gives.
And I didn't mean to ask you an unfair question there, Mr. Garcia, and that's a fair answer. Thank you. I'll pass the witness, Madam Hearing Officer.
Thank you, Mr. Cloutier. Mr. Suazo?
Give us just a second to get set up, please.
Madam Hearing Officer, may I interject while they get set up with a quick proffer?
Yes, Mr. Tremaine.
So as Exhibit 16 and Slide 4 of Exhibit 3 have caused a great deal of consternation. I've verified that we have a copy of the spreadsheet that is Exhibit 16 without the category column. So it was a copy of that sheet prepared for Mr. Powell prior to Mr. Garcia's work. And we're happy to strike slide 4 and provide to the parties a replacement in Exhibit 16. It does not have that column, whatever pleases the commission.
All right. How do the other parties feel about that?
For IPA&M's part, we feel that the slide 4 at this point has no value for the commission, so appreciate the division's offer to withdraw it. And I think, Mr. Tremaine, you're talking about column O that categorizes with the script in Exhibit 16. Is that?
In the PDF version that I'm looking at, I believe it's the category column. I believe that would be O.
Okay.
I'm not looking at the.
So you're just talking about striking the category column.
Striking providing the underlying sheet that does not include that column.
Let me put it this way, Madam Hearing Officer, IPA&M is willing to look at what the division is proposing, and we'll let you know whether we object, because we don't have it yet. So there's nothing to tender into evidence. And
all right, we'll take it up. Mr. Tremaine, if you would share it with all the other parties, and we'll take it up later. Mr. Suazo.
Thank you, Madam Hearing Officer. Good afternoon, Mr. Garcia. How are you?
Good, and you?
Fine, thank you. My name is Miguel Suazo. I represent Namoga in this proceeding. Some feedback. Sorry about that. That's all right. So, Mr. Garcia, I'm still trying to understand the formula issues that were identified during the cross-examination with you and IPA&M, and I may have some questions later, depending on how our experts who've not had the opportunity to review the formula. But I did want to talk to you more in detail about how this MOS spreadsheet came together. You testified that you personally created the MOS spreadsheet. Is that right?
I would say I led the team that I ran the building of it, and what I did is I met with multiple groups that are involved in the orphan project, engineering, inspections, environmental, etc., and basically had them, internally discuss with them and their supervisors and staff what items were deemed important to be tracked on a one base where everyone could go, everyone could track, so if the federal government or the state government had questions, it was easy for our management to provide them data, and that's how it came to be. So I built it by doing lots of stakeholder engagements on what they deemed needed for their teams.
Right, and that's kind of where I want to explore a little bit more deeply with you, because I feel like, so many hands went into this. I understand you supervised everybody. Was there a work plan associated with putting together this spreadsheet?
Yeah, basically, again, there was lots of databases. One team would track things here, another team track things there. It caused confusion. So per management, they wanted one place. So I met with every team and identified stakeholders, which typically consisted of the supervisor and the direct staff that dealt with this. To me, SOPs and databases should be built ground up. So I asked the staff and their supervisors, what are your pain points? What problems are you encountering with tracking your data, getting to management, getting to these reports? I'm not aware of the details, but I know because of the federal funding of the orphan program, management has reports they have to give them. So what was the pain points? What is everything you guys were struggling with? They met, they talked about pain points. They talked about things that they felt should be tracked. And what I did is I met with every team, sometimes multiple times. And, we kind of working meetings. Was this important? Is it not? For example, is the rig code important? We could talk about, is that important or not? Is it not? Okay, perfect. Don't put it in there. What I did after doing all that, I met with the supervisors. They were happy. They signed off on what their team needed. I then presented it to the bureau chiefs, engineering, environmental, financial, etc., and the deputy directors. I showed them basically the pain points that all the teams have had, what they deemed was needed for the Excel sheet, and legal too. And basically I had a meeting with all what I consider upper management, bureau chief and higher, and show them based on multiple meetings with staff and the supervisors and working through these are the categories your staff deems needed to be in here. do you approve? And so the bureau chiefs and the deputy directors got together, they reviewed it, and they signed off on it, saying, yes, they agree. What's in here will satisfy those reports that they are required to, submit to individuals. After that, sorry, it's a long process. After that, basically came, okay, here's the data catch-up phase, is what I called it. I believe we had 1 to 2 months where we basically directed all supervisors, and you'll see those supervisor names in the header of each colored column, was we've identified wells with legal by reading old hearing orders, searching our databases. Our old hearing examiner, Bill Brankart, assisted with it too, because he just had institutional knowledge that he'd been with OCD for so long. He had databases of like NOV orders. So with him and legal, our current legal staff, we went through, added wells to the Excel sheet, which is that black category. I added the API numbers and was able to scrape basically the Ulster information based off the API number and auto put that in there for everyone. Once that API is on, that was generated, legal vetted the hearing orders. They read the hearing orders, made sure they were appropriate, and they added a few other wells to the list based off things like settlement agreements and other things they have. And then once legal and management was like, okay, here's our list of wells, we basically opened it up to all the supervisors in the team and said, you have 2 months to play data catch up with everything that's in here. Is there bond information missing? Is there sundries we've approved? Get it all in there. And we had, I think at first we had bi-weekly meetings with management. I forget the interval we had. We had recurring meetings with management, showing them the progress of the data was getting caught up, meeting with the supervisors, meeting with the bureau chiefs, saying, here's what we caught up, here's what we've seen, here's issues we've encountered so far in our data cleanup. And then that lasted like 2 or so months. And then basically it's a living document now. So people are in it daily. For example, last week we plugged 3 wells that are on that Excel sheet. So, we go in and update the data. Did we approve the sundries? Did we check on the sites, et cetera? They're very living documents. Legal and management, if they pursue any other hearing orders or settlement agreements, I'm not part of that, like the settlement agreement stuff. They'll let me know, hey, we have a settlement agreement and we need to add more wells to it. And that's how wells would get added, is legal would let me know to add more wells to it. That's a long answer. Does it cover what you were looking for?
Well, it starts to touch on what I understand to be the very, broad scope of what the division was tasked with attempting to do. And I would like to kind of unpack that a little bit more granularly. So let's start with, just the first thing that comes to mind, and we can move on to other things. When you say staff identified pain points, what do you mean by that?
So I'll give you an example. Say the federal government wanted to know how many rigs were active this year. At that time, we didn't have in our database something that says like our rig rigged up on February 2nd. So that was the pain point that our staff identified of we should be tracking things like rig update. So we added that to the list of, so now when Loren gets sundries, he's in consistent talks with the rigs, and they'll tell him like, hey, 24-hour notice, we're moving. He tracks it, they rig up, he types it into the Moss Excel sheet. That was one pain point engineering was missing of, we weren't tracking rig updates. So we could provide the federal government or whoever it is with data they want. So really just trying to boost our data that we felt we could have captured better. Does that help?
It did. And can you remind me, just for the record, what was the purpose of the creation of the Moss spreadsheet? If you can do that in 1 or 2 sentences.
Yeah, simple is just a universal place for staff and management to go to see all aspects of the orphan plugin program.
And how many staffers would you say were involved at putting this together?
Individual staff and stakeholder meetings, 20, 25, including their supervisors.
So this was assembled by committee across the various divisions. Is it fair that to say that it's dependent upon the quality of the data that the staff members made a judgment call to include?
I would say the categories were put in there based on the staff and their supervisors, what they deemed needed. I would trust my counterparts that they chose what was needed for the application.
So lots of staff were involved, but going back to my initial question to you in terms of the scope, in terms of organization to put this together, was there a written plan with issues that needed to be addressed for purposes of creating this document?
I don't know if there was a full written plan on the issue that existed prior to creating it. I'm sure I have somewhere buried a list of issues that the teams had as they encountered it. I believe the initial issue was something on a higher level that I wasn't a part of. And I was directed because of whatever issue they encountered.
Sure. And is Mr. Powell the person who would know maybe the overarching structure of how OCD staff envisioned what was needed to put the MOS together?
Probably. I think he would be able to answer. And I think Adam talked about timeline. I think not to defer to Brandon, but he would know the inner workings on the real drive OCD needed a universal Excel sheet and what upper management was seeing across the division that they needed this for.
Okay. And you said that putting the MOS together required a manual review of old hearing orders, plugging reports, all that kind of thing, correct?
Correct.
And was there a methodology established to go through all of these old hearing orders and plugin reports that were determined needed to be reviewed?
Yeah, I'm not a lawyer. I spend a lot of time in the hearings bureau, and I used to work real close with Bill Brancard, our old OCD hearing examiner. Between him and some of our other legal counsel, they had records that they had stored and obtained through their careers of NOV, or I don't know what to call them, plug-in orders, I guess we can call them, that went to hearings and hearing orders were issued. So when it came time looking for what wells were to be on this list, Bill Brancard was a very good resource for me. I don't know how long he was at OCD, but I know he's been at OCD quite some time when we did this project. And he was able to provide me an extensive list of hearing orders that I should start with reading those, because our hearing database is very PDF based. So he may have a hearing order, but it doesn't say for sure that the hearing order approved the plugging. It could have been a dismissal of the case, etc. So I spent a lot of time reading them with our legal counsel, with their interpretation of the hearing orders and saying, does this meet the requirements to go on this list? Yes or no, with the legal counsel.
So using Mr. Brancard as an example, these are records that he just kept on his own, in his own filing system from his time when he was with the division?
Yes, and we can also query to an extent boards like NOV and force plugging in our database. OCD's database, the hearings go back to the 40s and 50s. So trying to search things from the 50s is a little difficult, but we can also search tags that the case types basically had, case type, NOV, etc.
So just to be clear on the time frame utilized to put together the MOS, it goes all the way back to the 1950s to the present, or I guess earlier this year.
I can't say for certain. I would have to look at what the oldest order on there is, but again, our database is more accurate. The more modern we get in time, the better the databases get, just because of the technology.
Sure. So I guess it's fair to say that this is not a 100% complete database. It's as complete as you could get it with the records you could access. Is that fair?
Correct. And I would say it's a living document, legal in what I will say their free time, which probably doesn't exist much. Also tries to review any historic orders. We may come across orders as other cases go on. It's a living document, so wells can be added to it.
Did you identify anything that you wish you had had in putting together this document that you just couldn't identify or find?
As far as like a column data, or I'm not sure I understand the question.
Just as far as data that you were trying to acquire, but that maybe not have been accessible for whatever reason.
Not that I could think of easily. There's a lot of long hours put into it, reading data comparisons, I don't think there's anything that I wish I could have done better at this time. Um, the only thing I wish we could do better, and you know, technology grows, is automating it more so there's less human interaction.
Sure. No, that makes complete sense. Is there a date after which you feel more confident about the information compared to older data?
I would say so. Again, going back, I became supervisor in 2023, started coming more into the orphan program late 23, based off memory. And the more data closer to my timeline being involved with the wells we plugged in, I'm more comfortable with, because I know those are sundries that I or Loren approved ourselves, rigs that we talked to ourselves. Um, I looked at sundries from like 2009 and other dates. I've vetted them. Just I'm not aware of things, and you'll see like it'll say rig update not applicable. I wasn't there in 2009, so I would say that data is a little rougher on the edges.
Okay. That's helpful. Thank you. Let's move on to orphan versus non-orphan wells. You testified that OCD plugged 100 orphan wells in 2024, correct?
Correct, based off subsequent sundries of plugging.
But industry plugged 773 non-orphans during that same year, correct?
Correct.
Okay. So over 3/4 of the wells plugged by operators were plugged by operators and not OCD, is that right?
Yeah, depending on how we look at the data. Again, there's some talk today between the parties of where does force plugging go. There's roughly 1,000 wells on that data pool. Industry plug 773, which is roughly 77% on their own, and then there's 100 even for OCD, so roughly 10%, and then I think it was 130, so roughly 13% were force plugging.
Okay. Now, I can't say that I fully have wrapped my arms around the formula that Mr. Cloutier asked you about, and I'm going to have some of our experts kind of look at that and see if they have any other thoughts or questions. But based on what I do understand, since we just got that formula this morning, I do have some general questions about the thresholds in the petition and your spreadsheets.
I have a quick objection to that statement Mr. Suazo made as a predicate to his question. That he might have been provided that by Mr. Cloutier this morning, but he never asked us for that, and so I don't believe it was ever sent to him. And what they did between each other is between them. Just would like the record to reflect that.
All right, thank you, Mr. Hall. Go ahead, Mr. Suazo.
So, Mr. Garcia, your testimony, you applied the thresholds that were listed in the petition. Is that right?
Again, yeah, so like using the mentality of or, I think we've talked about the confusion that there was there, but so it's like 90 barrels of oil equivalent or 90 days. I know, like we talked about Spur and that one well, the or mentality on Spur's well put it as marginal. When Spur looked at it and they used the mentality of the word and, it took it out of marginal. So I'm not sure, I guess, on how much you want to go in depth, because it sounded like my counsel was willing to scrap that exhibit. I'm not sure if, I guess that's an accurate statement. I don't know if you want me to talk about something that they might scrap, I guess.
No, I think there's enough kind of confusion around that issue to where we may need to come back to it. I'm just trying to understand for my own self that I am clear about what it is that you did. So those thresholds, the 1,000 BOE for marginal wells, 90 BOE for no beneficial use, those were chosen by applicants, correct?
The definitions of marginal, inactive, all that, those were what was in the petition by the applicants, correct?
Right. Okay. And did you perform any sort of economic analysis to determine whether 90 BOE is economic or uneconomic?
I did not.
Okay. Will you pull up that one slide? I think some of these other questions I'm not going to ask right now. Mr. Garcia, can you see the slide that is on the screen?
I can.
And this is the Rock Queen Unit 043, correct?
Correct.
Now, in looking at the bottom left chart, it shows from, if my eyes can see that far, from 1993 to 1999, there's pretty minimal production. Is that accurate?
I think it would depend on minimal. I think sometimes this chart scales weird because of the 2016 production. I don't have the numbers off the memory of what that production was in 1993 to 1999, but it had production consistently is what I would say.
Okay. But from 2000 to 2008, it shows, from what I can tell, zero production. Is that accurate?
Yeah, it looks that way. I would have to dive into the data to make sure there was no tens or anything hidden in there that the visual skews, but it looks to be non-productive those years.
So there's a 9-year period from 2000 to 2008, 8-year period where there's effectively no production, correct?
Correct.
Okay. And so by these metrics, under the rules proposed by the applicants, this well would have been shut in probably around 2001, correct? 2002?
Based on production, I'm assuming the well was shut in or, temporarily abandoned. Something could have gone on there.
But if you look further down the chart, starting with 2009 and through 2018, there is massive production, it looks like, from a well that was essentially dead for 8 years, correct?
Yeah, I'm not sure the exact volume, but there's a production spike in 2009.
Yes. Madam Hearing Officer, I think, given what we've heard today, I would like the opportunity to speak to Mr. Garcia again if we kind of discover some new information, but at this time, I don't have any further questions.
All right. It's 3:21. All right, let's see here. Mr. Sayer, do you have questions of Mr. Garcia? Thank you. Mr. Rankin, do you have questions of Mr. Garcia?
I do, Madam Hearing Officer. I do. Mr. Garcia, good afternoon.
Good afternoon.
How are you doing today?
Pretty good.
Good. You know me, I'm Adam Rankin with Holland Hart. I represent OCC in this case, this rulemaking, and I'm going to try to not retread, but I may touch on a couple of things if I feel like, just for clarification or for record purposes. A couple of things to start out with. In your testimony, you use the acronym SR. Is that for subsequent report?
Yeah, sorry if I didn't spell that out, but subsequent report. So OCD uses that in general for any work that's a report after work has taken place.
Then in your testimony, as with Mr. Diede, you define an orphan well, what you intend, your meaning of how you use the word orphan well, right?
Correct.
And it's the same, it sounds like it's the same definition or approximately the same definition that Mr. Diede it was using as well. Is that right?
They should be nearly identical.
Okay. And then you also talk about the forced plugging wells, again, being wells that are plugged by third parties at the bequest of or demand of the State Land Office or the BLM, right?
Correct.
Okay. And those are the forced plugging wells are different. How are they, if you could explain, how are they different than the orphan wells?
Yeah, and I know it probably causes more confusion because there's confusion around orphan wells to begin with. Forced plugging is a definition we came up with internally, basically to help Loren and I's day-to-day processing of applications. For example, if I was an operator and I need to plug a well that's not mine, there's extra checks that OCD has to do through our legal counsel to make sure we're not going to get in a bad spot, or to make sure this operator has the authority to go plug a well, which they're not the operator of record for. So by calling them forced plugging, it basically alerts us to internally remind ourselves we need to get with legal counsel and make sure we have all our I's and T's finished. Orphan wells are in a different boat. Legal and management has picked which wells those are prior to us. The process is different for us internally. They pick which wells are to be plugged. They issue POs, and then they tell us, here's an approved well list for you to plug. And we start working on the technical aspects. The force plugging, we get a lot of submissions from operators without notice in advance. For example, this week, I think we got 10 submissions from an operator that they want to plug wells they're not the operator of record for. So we call them force plugging because, it just changes our policy. We have to haul. We can't approve right away. We got to make sure legal's okay with them.
No, I actually, I think it's a very useful distinction, and that's why I'm asking you the question for the record, because I think this is an area that's become more common common in the last few years. Would you agree that force plugging has become a more common practice in the last few years?
I don't know if it's become more common in the last. I'll speak for the last 2 years because that's when I've been involved. I don't know if it's become more common. I would say OCD and operators are probably getting better at the process with each other on how to get these process through. In the beginning, there was a lot of wells that were plugged that would fit in the force plugging category that were plugged without OCD's notification. We found out about, 20 to 30 other wells that were force plugged without ever checking with OCD. So I would say we're just getting better at the process with industry on getting these out the door and approved prior to work taking place.
And just for the record, the issue here, right, is that under the division's rules and regulations, the only entity authorized to work on a well is the division designated operator, correct?
That's my understanding of how OCD processes our applications.
And that's true unless and until there's a force plugging order from the division or some other legal instrument that authorizes another entity to come in and plug that well, right?
Correct. We wait till we hear our legal counsel's thumbs up or, depending on the situation, a letter associated with that. Sometimes we don't have the letter because sometimes the force plugging are on federal wells, and BLM, their approval basically gives us their approval to process sundries without that legal letter from OCD.
And I'm just exploring this with you because I do think it's helpful for the commission to hear this and understand a little bit more about this process. That's not, it's a little bit outside the normal scope, right? Because it's not the actual operator that's plugging their own wells. It's third parties plugging other operators' wells. So I think I'm just asking you about this because I think it is helpful. And there's a lot of companies out there that are doing this. And I think it's helpful for the commission to know. So, just to further clarify how this process works, essentially your understanding is that the state land office or the BLM will send a letter making a demand of a third party for some legal reason or has some legal connection to the well, demanding that they plug that well that they're not the division designated operator of. Is that right?
Correct. Through state land office or BLM processes, which I'm not an expert on those, they basically tell operator A, we would like you to go plug this well because of X reason. And then they tell us, hey, we're being required to plug this. What do we need to do? And we work with them through that process.
Okay. So you don't know in that situation, you don't know the state land office or the BLM might actually know who the proper operator is, and they might be a division designated operator and they might be solvent, but for whatever reason, the state land office or BLM is not going to pursue that entity. Instead has gone after and asked for the third party to plug the well, correct?
I couldn't say.
I object. That calls for legal conclusions. Thank you.
Mr. Garcia, I know that you're not being offered here as a lawyer. If you can answer the question as part of the regulatory agency rather than as a lawyer, go ahead.
All I could say on the topic is state land office and BLM through their processes deem a need to chase an operator, and that operator comes to us and tells us they are being chased for whatever reason is state land office or BLM deemed fit. And we work with them as good neighbors to BLM and State Land Office to help get that process through so they can plug the well to meet their requirements under the other entities. Legally, again, that's why we loop in our legal counsel to vet that stuff with whoever they need to vet it with.
Yeah, I'm not, oh, sorry.
I was gonna say, we kind of just pause once we get the sundry. We kind of pause until we hear back from our counsel saying, good for your technical review to go.
Yeah, I'm not trying to ask you something you don't know. I'm just, the point here I'm trying to get at, I guess, ultimately is that the difference between an orphan well or at least a difference between an orphan well and a force plugging well is that an orphan well, for sure, right, that the entity is no longer around or viable. But in the case of force plugging, the division doesn't know whether that other entity is solvent or not, or what the situation is, only that the other agency out there is asking for some other party to plug that well, right?
I would say for orphan wells or wells we've vetted through various legal processes like hearings, ACYs, etc. And those are orphan wells. The force plugging, they may have hearing orders, and State Land Officer BLM may, beat us to plugging that well by having someone else do it, or they could not. That's probably more of a legal question on if they all are orphan or not. I couldn't say.
Sure. Okay. Understood. I may ask you a couple more questions about that, where you break out the difference between or lump them together, force plugging and orphan wells. Okay. I didn't mean to belabor that point. I just think it was helpful to understand a little bit more about the difference between those two pathways. And that's, I guess I'll just turn to this slide here. It's your slide 3 on your slide 3 of your exhibit 3, where you kind of show that over the last year, at least in 2024, OCD's plugged 100 wells, and then there's 129 of these force plugged wells. And those are the wells we were discussing just now, right?
Correct. Those are the separate categories and kept them separate because of that, distinction between them.
Right. And I've highlighted here, and you mentioned this a little bit in your intro, whether you lump them together or not. If you do lump them together, it's 23% if you count them as all orphan wells, right?
Correct. Yeah, it would be 23% roughly.
And I'm just, I guess my point here is that the division hasn't gone through to ascertain or determine legally whether those force plug wells would fall under your definition of orphan wells, right?
I don't think I could fully answer that. Again, we typically wait on legal to assert whether or not we can approve the plugging. There has been a few force pluggings we've had to tell the operator that's trying to plug it. At this time, OCD can't approve this. And then we basically refer them to our legal counsel for further discussions. So I'm not sure if I could say all of these wells are not orphan or not.
I guess my question then is, if you put them in the force plug category, OCD has not performed the analysis to determine that there's not that they meet the orphan definition, right?
Me and my team have not performed it. Now, if legal does when they talk to these operators on a one-on-one basis, I couldn't say that.
Okay. I have a couple follow-up questions for you on the creation of the master orphan spreadsheet. I was curious, when did OCD decide to start building that spreadsheet?
That's a good question. I don't know the exact day in mind. I would say probably early 24, if I had to guess.
Was it
maybe sooner?
Was the decision to create that master orphan spreadsheet part of this rulemaking effort?
Not to my knowledge.
So
I believe it was just internal items that management was seeing could be corrected.
So rather than being part of or preparing for this rulemaking, the division decided to make this master orphan spreadsheet as part of its better management of its orphan well situation.
Yeah, my limited view into the orphan world program at OCD is this was really just a step in the right direction of getting us better, similar team, one goal, hopefully future automating this. It was just a step in that direction. I was not part of the original this rulemaking discussion, so I don't know when those took place. So I couldn't say relation of timelines to this.
So the intent of the creation of I'm going to call it the MOS, was to be able to better manage, have a single uniform source of information for management purposes, to be able to track and manage orphan wells, right?
Correct. Like I could tell you one day, I don't prep the reports for the federal government, but like I know one day I got a call and they said, hey, we told them we plugged all these wells. Now the federal government would like to see the sundry. And that's why in the MOS now going forward, you see the hyperlinks in there. So it's easy for those who report to the federal government to kind of copy and paste the hyperlinks into whatever reports they're submitting. So to me, it's really just a better management tool.
What did the division do before it had the MOS? How did it manage its orphan wells before that?
I do not know. I wasn't part of it really prior to MOS. MOS was kind of my intro to orphan program, as well as starting to take over the rig management. So how they report and all that for me, I couldn't answer that.
Who would be the one to be able to address that question?
Not to kick, but possibly Brandon, and that's a maybe there because there's other teams that are the OCD special projects team overviews the entire orphan program, and none of them are testifying today, I don't believe, for this whole hearing.
Would that potentially also fall under Mr. Wrinkle's purview?
About how we reported prior to the MOS?
Yeah, how the division managed orphan well program prior to establishing or creating its MOS spreadsheet.
I'll let you ask him because I couldn't say for sure whether that's a yes or no.
Okay, so I guess maybe Brandon, maybe Justin. Okay.
I would ask both.
I'm sorry, what was that?
I would ask both of them if I was you.
Okay.
Sorry.
No, that's all right. And the intent of that list is to capture all orphan wells under the division's definition that exists in the state, whether state, federal, or private minerals, correct?
Correct. It was just orphan wells.
Say that again?
Correct. We were just looking for orphan wells within New Mexico's state limits.
Right. So without respect to whether they're state trust minerals, federal minerals, or private minerals, correct?
Correct. There is federal wells on there because we have plugged multiple federal wells per BLM request. Again, being a good neighbor to our regulatory sibling, I guess. So there is BLM federal wells in there because we're also helping them out.
It sounds like it was an arduous process in large part because some of the determinations about whether a well is orphaned or not is dependent upon having to review individual hearing orders, correct?
It was a lot of hearing orders.
So, and I think you said there was some interpretation required when you reviewed hearing orders, just sort of my understanding, and for the record, what interpretation was needed to understand when you reviewed the orders?
I mean, I guess, I do a lot of hearings on my other part of OCD life. And this is a broad statement. I feel like our OCD orders nowadays are maybe cleaner and simpler to read. When we started reviewing orders prior to my time at OCD, there was some confusion in them. They're not following our similar templates we use nowadays. So I leaned on our legal counsel for their interpretation. Again, some of the orders were dismissals, continuances. There's some older orders that are, there's one example that I tease my counsel that I hope they never do it because it's one order, one case, and there's like 73 operators and I think there's like 700 wells on it. And they were all force plugging potential wells. And so I really relied on the legal counsel for that order because that order has been amended multiple times. And the order says like the wells in Exhibit A need to do this, Exhibit B need to do this, Exhibit C need to do this. It just goes 1,000 different ways in some of those older orders. So they get real messy the older you get. I think the orders nowadays are a little cleaner.
Yeah, there was so there was no like electronic database where you could see a check mark, right? If something was orphaned, right? You had to go through and kind of create it from scratch based on these old orders, right?
Yeah, I mean, the older we get, the more PDF we get too. So there's no just query we can run.
Okay. just Mr. Suazo and Mr. Cloutier went through a lot of my questions. So I'm just trying to make sure I don't duplicate myself unnecessarily. I think I'm going to raise an objection if I ask this question, but basically you're not the person to ask. Of the 100 wells that OCD plugged in 2024, how many has OCD sought to redeem the bond for?
I guess I was pausing because you expected an objection. I would not be the person to ask.
Is that your question? Is that for you, or is that for Mr. Powell?
Yeah, I would defer to probably Mr. Pell. All I will note is in the MOS, in the yellow category, there's a bonds team, and there's talk about bonds numbers in there. That's the extent of my knowledge. Now, how much we've sought, I couldn't answer.
Mr. Garcia, I'm just following your advice. I'm going to ask each of you, okay? And as things get kicked down, I'll just ask the next one to the next witness, okay? So so that's not your area, and you can't tell me of the wells you plugged how many the division has sought or to redeem, right? So can you tell me? Well, again, I guess I'll direct it to Mr. Powell, but you can't tell me if the division hasn't, why it hasn't, or what the issue is with bonding. I'll direct that to Mr. Powell.
Was that a question, I guess?
No, it was just me. Like,
okay,
it was
no, that's
me.
fine.
Sorry, it's getting late in the afternoon. Sorry. All right. Sorting through. I mean, I had some issues last night sorting through what Mr. Cloutier and Mr. Suazo were reviewing. So I'm just trying to make sure there's a few things I might want to just. I don't know that I need to clarify any more than they did on the testimony, but I'm going to just touch on one or two things here just to make sure it's clear. Okay. What I gathered from reviewing, and I didn't look at the formula that you used for your Exhibit 16, so I wasn't able to discern myself whether the actual spreadsheet that generated this pie chart had an error. But in reviewing the language of the spreadsheet, I did discern for myself that there might be a problem, and I think you explored that thoroughly with Mr. Cloutier and Mr. Suazo. But the bottom line is that this pie chart is not accurate or reliable because it was using the OR for both the marginal wells and no beneficial use wells, correct?
I would say the accuracy. Sorry, go ahead.
Sorry, let me just clarify that this is Exhibit 3, Slide 4 that I'm referring to.
Correct, and I can see it. I would say the accuracy matches the OR mentality, and I know we've talked about it a lot. I think there's just a lot of confusion, and the real takeaway from this, and I know you're going to review with your clients tonight, is my takeaway is the rule. I'm not a lawyer, you know that, and so my reading and talks to management was kind of to treat it with the word "or," which I did. It shows the numbers that it shows, which again it is kind of like a worst case scenario for the commission to understand of if they enacted it, this is how many wells they would be increasing bonds on potentially. What I will say is I think the OCC, when they evaluate this and the parties, I think everyone's just looking for a clean and concise rule. Now, so is that a days or BOE? Is it a days and BOE? Is it just a BOE? I believe others will testify more about it because, to my understanding, there's been more talks about the wording in the petition that I wasn't part of. But to me, a simple rule that's clean and cut for OCD and operators to go by, so there's no debates later down the road of does this well meet it or not, is really what I'm trying to get across with this slide. Of there was some confusion, we just need a clean rule. Now is that what that looks like? I don't have the answer to it at this time. I just think we need a clean, easy to read rule.
Yeah. So, but just this pie chart does not reflect what the wells would be that are marginal or no beneficial use under the petition as it sits in front of the commission right now, correct?
After talks with, sorry, I'm horrible with names. I'll call him by his first name, Mr. Andrew from IPAM, after talks with him and seeing how his client reads the word and, this would not show the and mentality that him and his clients talked about, which they believe is the way the petition is supposed to read.
Okay, I'm just trying to get it into one spot. All right. I was interested in this last slide 11 of your exhibit 3. Although you don't provide a lot of testimony on this slide, okay, in your written testimony, nor did you really give much around it in your summary. But in your testimony, you said that these wells ultimately became orphan wells, as I understand, right? And that OCD had to plug them. But they'd previously gone through a series or numerous transfers from one operator to another. And as I understand, the issue here, the division identifies that as one of the indicator of potential orphan wells when they get transferred down the chain, correct?
I don't know if I would say OCD as a whole believes that. I think I put this slide together, and you're right, I probably could have put some more words in here about the slide was to kind of show these are the same wells that Loren testified to, and he had talked about with each cell, data gets harder and harder to come by. So this really wasn't taking a stance on the cells. It was really just showing the wells that Loren talked about, how many times they were sold and how it became harder each time to get the data to plug the well. That's kind of the take on this slide, is they're the same wells. And to clarify, the wells on the right side are the ones OCD plugged. The Cato San Andreas are the wells that were deemed forced plugging. Another operator plugged those wells.
Okay. Now, I mean, you've read the petition and the proposed rulemaking, and Mr. Morgan did a very good job of reviewing this portion of the rule that identifies the concerns about and empowering the division to review transfers of operatorship to ensure that the transferee has the proper financial wherewithal to manage the remaining life cycle of the wells, right?
I'll say I can see what you
Objection,
said.
multifarious question. I heard about 2 or 3 different questions there.
That probably is true.
All right, Mr. Garcia, can you answer the question, or do you want it broken down?
All I will say is I have not been present for all testimony, Mr. Rankin. We've had a lot of other items come up in the background that I've been dealing with outside of the hearing. So could you refine the question, I guess, is it specifically the slide we're discussing?
Well, there's a series of slides, and I guess you're aware that the proposed rulemaking here provides the division with additional powers to review the financial wherewithal of an ability of the transferee to manage the life cycle of the wells that they're going to be operating, correct?
Yeah, I'm aware that the proposed petition talks about OCD having, like you said, some oversight of the transfers and all that stuff.
And once the division has that power, assuming this proposed rule gets adopted as proposed, the issues that are identified in this slide 11, do you expect them to be resolved by the division's ability to review the capacity of the transferee to manage the life cycle of the well?
I think in certain situations it may help. In certain situations, I don't know about the difference. I don't know if I have a personal opinion on this overall.
Okay. But so just so I'm clear, I mean, you put the slide together for a purpose, right? To show that the more times often, you tell me what was the purpose of showing the fact that these things got transferred from one operator to another?
It was just to show the divestment history of the wells that Loren discussed in his testimony, just so the commission and the parties had a question or answers to questions. I kind of assumed that somebody was going to ask how many times they were sold, which I believe someone did ask Loren and he couldn't answer. This slide is basically in support of those questions.
So it wasn't intended to address the division's concerns or ability to manage or review, oversee transfers going forward under the proposed rule?
My testimony doesn't have any opinion on overall supporting or going against the rule. I believe that's been reserved for Brandon, as we kind of discussed. He'll talk about changes in support and about the petition. This is just more factual testimony of these wells are wells that we've encountered issues with. Here's how many times they were sold.
So I'm going to ask you a question about transfers. Has the division conducted an analysis to determine how many orphan wells the provision in the rule that addresses transfers might prevent from devolving to the OCD as orphan wells?
I have not.
Are you aware of anybody at the division doing analysis along those lines?
I am not.
All right. I think you've answered. I think you've answered all my questions. Let me just make sure. Yeah, I think you have, Mr. Garcia. It's a pleasure. Thank you very much for your time today. Appreciate it.
Thank you.
Right. Thank you, Mr. Rankin. Mr. Maxwell, do you have questions of Mr. Garcia?
No questions. Thank you.
Thank you. Is Ms. Nanasi with us? Mr. Moore?
No questions, Madam Hearing Examiner. Thank you.
Thank you very much. Ms. Fox, are you going to have questions, or Mr. Tisdale? You
Just
will.
very few questions.
Okay, I'm asking because we need a short break before public comment. So can
Okay.
you do that after public comment?
I'd be happy to. Yeah.
Thanks so much. Let's come back at 4. Let's come back from the break, please. All righty. Ms. Gerhart, would you like to come up to the speaker's box up here, please? Good afternoon. My name is Felicia Orth, conducting a hearing on well plugging and financial assurance. We've come to another public comment session today. I have several people indicating a desire to offer a public comment. Just a few things about that. I will ask you to spell your first and last name because we are making a transcript. Also, please speak at a deliberate pace because we are making a transcript. I'll ask the rules, ask that you be sworn in. That is to say, I'll ask you if you swear or affirm to tell the truth. And I will ask you to keep your comments to 3 minutes. In the event you have a lot more than that to say, please submit your comment in writing to Sheila Apodaca, the Commission Administrator. So, Ms. Gerhart, would you spell your first and last name, please?
My name is Sayer Gerhart, SAYRE Gerhart.
Thank you. And do you swear or affirm to tell the truth?
I do.
I'll start your time.
Okay. My name is Sarah Gerhart, and I live in Corrales, New Mexico. And I am really just a member of the public coming to support the modernization of the New Mexico's bonding and cleanup rules. And I really know that this is hard work. I've been an elected official myself and want to commend everybody for working on this. My reason for speaking also is because as a member of the public, we are paying attention and I know it's very nuanced what, even I was hearing for the last half an hour in the room, but it's also very simple. If you drill it, you clean it up. And as a taxpayer and as an advocate for our stewardship of our beautiful state, I hope that the commissioners will modernize the rules and prevent the taxpayers from picking up the burden of cleaning up after other people, and also that we resolve the orphan wells situation around the state, and that's really all I wanted to say.
Thank you very much, Ms. Gerhart. Do we have Kathleen Epp on the platform?
Okay, can you hear me?
Yes, I can.
Okay.
Would you spell your first and last name, please?
Okay, Kathleen is Kathleen. My last name is Hepp, Hepp.
Thank you. Do you swear or affirm to tell the truth?
Absolutely.
I will start your time.
Okay. Well, hello, my name is Kathleen Hepp. I live in New Mexico for 30 plus years. I'm originally from Pennsylvania. I raised my boys here, my 3 boys in Moriarty, New Mexico, and they all attended public schools. All 3 boys were in wrestling, and it gave them a structure and it gave them discipline to become the good, hardworking men that they are today. So that being said, it also gave them morals and values. Sorry. They've also received scholarships, each of them, to go to college. My hope is that their children have the same opportunity as they did. Cutting the funding would put a big damper on that opportunity, I believe. One of my son's job is working with the railroad. And I consider that a very good career for him. I'm proud of him. It would be a real impact on his job and the community around to get products, meaning a rise on their prices and less product for Americans. Increasing products, in my opinion, in New Mexico, we can't afford it right now with the increase of everything else. It would hurt our community because that we cannot afford that. For you guys to raise the regulations, that would hurt everyone. It would also probably drive the companies out of New Mexico and do business elsewhere. So please consider people like me and my family before deciding on any new regulations. And I appreciate the time that you're taking to listen to me. Thank you very much.
Thank you, Ms. Happ.
You're welcome.
Vicky Gottlieb, do we have Vicky Gottlieb on the platform? She reached out earlier to speak at 4. All right, if she joins us, Ms. Apodaca, let me know.
I do see her on the platform and she has permissions to unmute.
Oh, okay. Ms. Gottlieb, I believe you have permission to unmute. Ms. Gottlieb, you might need to press Control-Shift-M. She may have stepped away. All right, let's move to the next person with their hand raised, Sheila. Right, this is Petra Ligon or Ligon. Can you unmute yourself?
Can you hear me?
Yes, thank you. Would you spell your first and last name, please?
Yes, it's Petra, last name Ligon.
Thank you. Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
Okay, so hello everyone. Thank you, commissioners, for allowing me to speak today. My name is Petra Ligon. I was born in Berlin, Germany, and moved to the United States when my husband was transferred to Fort Eustis, Virginia. After 3 years, I too decided to join the Army working as a transportation management coordinator. I separated after my second enlistment and worked for various companies, mostly in the administrative field. Kirtland Air Force Base was my husband's last duty station. He retired in 1997 after serving 24 years in the military, and we both retired permanently this year. I realize New Mexico heavily depends on the revenue it makes from oil and gas companies to fund education, Medicaid, and other programs. Nevertheless, increasing fees for smaller oil and gas companies will only drive them to go elsewhere. As a veteran, I know that the oil and gas companies are composed of about 20% veterans. Supporting those who have served our country is important, and we should not take away that opportunity. With that said, I believe it's very important for our state not to only rely on the revenue from oil and gas, but to incentivize larger companies and manufacturing businesses to move to New Mexico. I'm asking to please consider the importance of oil and gas for our state when deciding on this issue. So thank you for your time.
Thank you very much, Ms. Ligon. We'll move now to Steffi Weisberg.
Hi, can you hear me?
Yes, thank you very much. Would you spell your first and last name, please?
Steffi is Steffi, Weisberg, Weisburd, as in
Thank
David.
you. Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Thank you for allowing me to speak today. I've lived in New Mexico for 35 years. I treasure the state's natural beauty and how responsible use of our resource benefits us all. Unfortunately, our state has suffered a surfeit of examples of companies abusing the trust we place in them to operate conscientiously and return the borrowed environment to its prior state. The oil and gas industry in particular seems to be structured to encourage infrastructure abandonment from small operators who acquire marginal wells that do not guarantee enough income to be cleaned up by their owners. The problem will only be exacerbated by the eventual decline of fossil fuels, leaving more stranded assets littering our state. Requiring operators to put up a bond linked to realistic well plugging and remediation costs is common sense. After all, we wouldn't object to a landlord requiring a security deposit and evidence of cash flow to pay rent for an apartment. If renters treat the property with respect, they will get their security deposit back. The impact of abandoned wells goes beyond plugging and remediation costs. They can emit substances toxic to humans, livestock, and wildlife and contribute to climate pollution. And we're all already confronting the costly consequences of climate change. Where I live, I'm terrified of wildfires burning our communities. We have soaring insurance premiums. We have water shortages. People are having to drill deeper for wells, and we have a harder time in the heat. Nationally, climate-driven extreme weather has bumped the average number of billion-dollar disasters from 3 per year in the 1980s to 19 per year over the last decade, according to Climate Central. For the first 6 months of this year, there have been 14 disasters costing $101 billion. I was on when Senator Townsend and Representative Montoya mentioned HB 403. It redirects funds from education towards the reclamation fund in lieu of modernizing bonding requirements. I do not like taking the option of support away from education, nor relying solely on a rescue fund after the fact. A sufficiently sized bond acts as more of a deterrent to bad behavior than cleanup monies widely sourced from taxes on the industry at large. Some of the reclamation funding also comes from the federal government, which is abandoning decades of environmental protections and the funding behind it. We must stand up for ourselves. I urge you to adopt rules that protect our communities and the lands, water, and air we all depend on to live. Thank you very much.
Thank you, Ms. Weisberg. Ms. Gottlieb? Hello.
Yes.
Would you spell your first and last name, please?
Yes. My first name is Vicky, Vicki, Gottlieb, Gottlieb, E as in every, B as in boy.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Good afternoon, Chair and Commissioners. My name is Vicky Gottlieb, and I'm speaking as a resident of Placitas, where I've lived for 18 years, and other places where I've lived since 1970, Albuquerque, Roswell, Santa Fe, and El Rito. I strongly support the proposed bonding rule changes. Since moving to Placitas, I've helped our community push Sandoval County to require air quality monitoring by the gravel operators here, enforce their contracts, and require reclamation after operations shut down. Resource extraction is common in New Mexico. It's also common sense to make companies extracting resources responsible for the expense of work to clean it up. 100% of the time. When I worked, for the State Department of Information Technology for 12 years before retiring, one of my responsibilities was reviewing all agencies' information technology contracts. We worked hard to get the bonding requirements for expensive single and multi-agency projects increased. So I have firsthand knowledge of the imperative for adequate bonding, as well as the business of all state agencies who have anything to do with oil and gas drilling. Well cleanup costs are substantial, and they fall to the state largely because oil and gas corporations are not required to post sufficient bonds to cover them. This exposes taxpayers, public funds, communities, and the environment to harm and contributes to a legacy of pollution in New Mexico. As a grandparent, I owe it to my grandchildren to protect the environment, conserve state funds wherever possible, and ensure a legacy that encourages them to consider New Mexico the best option for working and raising their families in the future. Your decision impacts future generations of New Mexicans as well. You owe it to them to support the proposed bonding rule changes. Thank you for listening.
Thank you very much, Ms. Gottlieb. What do we have here? Kevin Kirby, can you unmute yourself?
Okay.
Hello.
My name is Kevin Kirby, KevinKirby.
Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Members of the New Mexico Oil Conservation Commission. Son, we've got to talk about this bond issue thing. Yeah, I know we don't talk a lot about your oil business, but maybe now is the time. If your mother were here, she would tell you what she always told you. Clean up your mess. Your room is like a pigsty. I'm sorry, she's not here to tell you herself. But you never listened. You and your buddies have made a mess of New Mexico, and this bond thing just said